All right, our final session is on alternatives to tort liability. Our moderator for this session is David Haddock, who is a professor in the law school as well as in the economics department.
Like some of the other people here, I'm a Cyril Fellow, and we were, as a part of that responsibility, we were drafted into chairing or moderating these sessions. And looking at them, I think they've decided to place us in the session where we knew the absolute least, so we could learn the most, trying to maximize the education here. And so I'm going to be very interested in learning what I can during this session. Our presenters are Michelle Mello, who's a professor at the Harvard School of Public Health, and she'll be followed by Paul Barringer, who is General Counsel of Common Good, and both of them will be speaking to some extent on a concept called health courts. And then Paul Rubin from the Emory Law School and the Emory Economics Department will be considering a different way of dealing with some of these problems by tort reform by contract. So I begin with Michelle.
Well, I'm delighted to be here, and even though I am an empirical researcher, I'm especially delighted to be on this panel where we're going to, I think, have a very interesting discussion about policy experiments. I've learned that if the second law of social science research, as Eric said, is that the South is different, the first is never agree to present an empirical paper in less than 15 minutes. People's eyes start to bulge, and it can lead to cerebrovascular events, usually in the speaker. So I'm not going to present a paper today, but I did want to share with you some work that I've been involved in for the last few years, along with Paul Barringer and his colleagues at Common Good. We have an unusual partnership that's facilitated by a grant from the Robert Wood Johnson Foundation to develop an idea that has been percolating through the states, really through the last couple of malpractice crises. And that idea is to experiment with small-scale demonstration projects of administrative compensation for medical injury. In the last couple of crises, there's been interest in this, but there have always been barriers. And so what we're doing in the current project is, at Harvard, we're doing some research to try to analyze some of those barriers, constitutional issues, issues about what it will cost, and other points. And at Common Good, they're doing some political consensus building to try to transcend some of the political barriers. So I want to talk to you today about, first, what the proposal is briefly, although I think that Paul will go into that a little bit more. And then secondly, some of the research we've been doing around the interface with patient safety. One thing that we haven't talked about today is that the medical liability system is supposed to do more than just get compensation to people who are injured. It's supposed to be a system for holding medical providers accountable for substandard care and for deterring substandard care. But I have some skepticism about how well it does that, and I think that the proposal that we want to talk about today will do a better job of that. So the larger question of how can we reform the tort system to make it a better agent of patient safety is a question that I'm interested in as a public health researcher. So let me just briefly go over the outline of the proposal. It's put forth in more depth in the paper that's in your packets. The core elements are removal of medical injury claims from the regular tort system into an administrative system that would be an exclusive remedy for those who opt in to the system. And by that I mean both providers who opt in through their insurer to participate and patients who opt in by choosing a provider who is covered by this system. So the initial stage of adjudication would be at the level of the hospital and health insurer. They would be encouraged to disclose the event and to make an early offer of compensation after doing a root cause analysis. And if that did not result in a satisfactory resolution of the dispute, it would then go to the health court, which is an administrative tribunal set up by the state, staffed by judges who are assisted by neutral medical experts. So in order to facilitate what we think will be more reliable and expeditious decision-making in this system, we think that decision aids will be an important element. So one element, as I said, will be the use of neutral rather than experts retained by the litigants. A second element will be the use of precedent. So rather than having the decision maker approach each case with no information about how similar cases were decided in the past, we would have available a wide variety of information about similar injuries and how those claims were resolved and what awards were given out in those cases. We would also have convened on a regular basis panels of medical legal experts, including consumer representatives, representatives of the bar, and medical experts, to try to come up with some consensus statements about events that we think really are avoidable. And we can say that in a large proportion of cases, these are events that should attract compensation. We don't need to litigate them to death to know that. We would call these accelerated compensation events, and there's a lot of research on this idea that suggests that for some specialties that are commonly the targets of malpractice claims, we could get rid of up to half of our claims through a process like that. The third core principle is that we are going to get rid of the negligence standard, which we don't think works for patients and we don't think works for doctors, and replace it with a more generous compensation standard of avoidability. If it's an injury that should not have happened in a well-designed system of care, you should be compensated for it. This is not a no-fault system. You still have to prove causation and avoidability, but it's a much broader eligibility standard than negligence. Fourth, we would subject non-economic damages to a schedule that would propose both a ceiling and a floor for injuries of different levels of severity based on empirical research about how the public values different states of ill health and disability. And then finally, we would build into the system mechanisms to improve patient safety and reduce the likelihood of injury in the future. And I want to talk about that today. So I know Paul will talk about what we see as the advantages of the system. I'll just go over them briefly. One thing is we think it will be much faster way to get compensation to injured patients, more reliable in terms of being able to predict what injuries are going to attract compensation and what are not. Certainly easier for people with a range of kinds of injuries to get into court and receive compensation than it is in tort. Easier to control the costs of the system because although we'll be letting more people in, we will be able to centralize and impose political decisions about what socially optimal level of spending on the liability system is rather than leaving that to an uncontrolled and decentralized process. And then finally, and most important for my purposes today, is I think this is a system that can really improve patient safety. You know, most, I think, claims attorneys who believe in the tort liability system will defend it not as a great mechanism for getting compensation to injured people. There are definitely more efficient ways to do that. But as a mechanism for deterrence, for inducing providers to take precautions. But my research and the research of others suggests that this is really an overly sunny view of how the tort liability system works. That for a variety of reasons, we don't see this kind of deterrence taking place. And one reason is that doctors will tell you they don't know what negligence means. It doesn't send them clear signals about what behavior is and is not okay. A second is the issue of accuracy, which is more an artifact than a reality, in my opinion, based on the research that I've done. But the point, as far as deterrence goes, is that physicians still think that outcomes of litigation are essentially random. And you can't deter someone who doesn't believe that the signal is being sent to him means something. And then the final reason is that, as has been mentioned earlier today, research at Harvard indicates that only a tiny fraction of instances of negligent care ever become claims. So this is not a system that is designed to deter medical negligence in a comprehensive way. Health courts, I think, have much more promise for a couple of reasons. One is this greatly expanded eligibility for compensation. So many more instances of suboptimal care become claims, result in an economic sanction for the provider. And then the second reason is that the decision criteria are much more explicit. So providers know what will be expected of them, and they have a pretty good sense of what kinds of outcomes are going to result in a payment. And that should increase the celerity and the certainty of the deterrent signal. There's a lot of research coming out of the emergent patient safety movement about what deterrence means in practice. And I think it's useful for us to consider that when we talk about tort reform and the medical liability system as a health policy system. What we know is that to improve patient safety, we need two things. One is we need to change the culture in hospitals and doctors' offices in a way that facilitates safety. And one key element of this is making doctors comfortable sharing information about errors. Doctors and hospitals tell us that one of the leading reasons for not being honest with patients and families about the fact of error, or even being willing to discuss it with their colleagues, is fear of liability. Now, is this the only reason that they don't disclose it? Definitely not. There are tons of other reasons having to do with the culture of medicine and the basic human tendency to not want to admit error. that creates this phenomenon. But does the threat of liability help? Of course not. It makes the system worse. And once we correct that problem, we can begin to address the excuses that physicians sometimes make for not being honest about error. We can lead them to a culture where honesty is facilitated and where dishonesty or lack of transparency is not tolerated. The second thing we know is that there has to be a scientific basis for patient safety improvement. We can't just go about implementing scattershot interventions to try to address medical errors without understanding what's going on, what are the major sources of error, and how can we really address them. And so in order to get that science going, we need to have a feedback loop of information. We need to collect it, we need to analyze it, and we need to feed it back to the people who are in a position to make a difference. And that's, I think, where the liability system can really come in as well, is as a source for generating information about bad things that happen to people in hospitals. So we envisioned that a health court would address both of these sort of pillars of patient safety improvement. One, by moving to this avoidability standard, we think we'll be able to encourage a great deal more disclosure and transparency about the fact that bad outcomes happen in medical care. And we can talk about them without attaching the stigma of negligence to those discussions. So, my contacts with doctors say that doctors are willing to acknowledge that bad outcomes happen, but they're not willing to admit negligence. So let's move beyond that and open up discussions. And then secondly, let's think about how we can use the medical liability system as a data source. We have a tremendously rich source of information about serious medical outcomes that is virtually ignored, as you've heard today. Very little use of these data in any systematic way to study medical error. So by implementing a system that collects and centralizes this information and feeds it back to hospitals, we think we can really make some gains there as well. I'll stop there and let Paul pick it up.
Thank you.
Good afternoon. My name is Paul Barringer. I'm here from Common Good, which is a legal reform nonprofit in Washington and New York. And I'm so happy to be here today. I actually had a rather arduous travel day. My flight, I was bumped from my flight, and it turns out, I think spring break these days actually, and you all in academia could tell me, confirm this is the case, actually lasts a month and a half or maybe 2 months. Because anytime you're flying between mid-February and mid-April and there's a problem, they say, oh, it's spring break going on. So I'm bumped from, consistently bumped and bumped and bumped, and so I finally made it here. I think Woody Allen says something to the effect of 90% of success is showing up, and I'm glad that I got my 90%, but it was a little bit in doubt a little while ago. So I was disappointed that I missed the earlier part of today's session, because from looking at the agenda beforehand and in my ample time at the airport in the taxi today, I see that there were a number of fascinating presentations, and it really is an honor for me to be at the tail end of a group of such distinguished presenters and have this opportunity to speak with you today, so thank you. I particularly like to thank Henry Butler for the invitation to be here today, and also Derek Gunderson for his work in setting up all the arrangements. Again, I work with Common Good, a nonprofit in Washington, and we've been working over the last couple of years with Professor Mello and her colleagues at the Harvard School of Public Health to develop a conceptual proposal for what a system of health courts might look like at the state level. We've been working on this project with the support of the Robert Wood Johnson Foundation, and as part of that effort, we've been reaching out to stakeholders all around the country to cultivate interest, to try to generate support in the idea of trying pilot projects to begin to test the feasibility of this idea. And as part of that, we've also been working to solicit input from folks around the country about the best ways we might take this model, turn it into something on the ground that's actually real. So in all those ways, I'm just really happy to be here to have the chance to share a little bit of information. We certainly hope that this is something that you all may have an interest in. We'd love to have your feedback and input as we continue to work to make this model evolve. Now, I know it's the end of the day. It's very time sensitive, so I promised Henry that I would keep this talk to under 45 minutes. I think I have all 6 minutes at the moment because I've got through with my warm-ups. But what I'd like to do over the next 6 minutes, or maybe 7, because everybody's really always happy when you talk for less rather than more, is to run really through 4 things. One, to provide a little bit of contextual information about the context within which this proposal arises. Second, describe for you the key elements of this health court proposal. Third, outline for you some comparisons with existing systems both around the U.S. and around the world. And then finally, describe for you some of the ways that we're seeing this proposal translated into specific initiatives at the state level in particular. Now, context. We clearly have a medical liability system which has major shortcomings. It's very inefficient. It does little to deter substandard practices or provide incentives for overall improvements in quality of care. It's quite unpredictable in its application of standards. Now, there's been a lot of interest in this issue for a long time and a lot of political polarization around the medical liability issue. So in a way, it's not surprising, given that polarization, that we haven't been able to see substantial progress on this. And certainly in the wake of November's election, the prospects for conventional kinds of tort reforms in Washington are even more bleak than they perhaps were before that. So our hope is, and we're beginning to see some evidence that this is the case, that innovative proposals like the health court or administrative compensation proposal may be just what the doctor ordered in the new political environment, where there's really a willingness to understand that and accept that there is a policy problem, but a desire for new approaches and new solutions. Certainly, approaches to remove tort liability from the medical injury context or from the tort system and put it in an administrative scheme have been around for a number of decades. Our hope is that with the nexus to patient safety, that this time there may be greater opportunities for traction. Now, what are the key elements of this proposal? Well, Professor Mello outlined those much more eloquently than I will, but just in brief, to summarize, what we envision in this proposal is that the judges or adjudicators in this system would have some training or expertise in healthcare issues, that they would rely not on the competing war of experts for hire, but rather on neutral or independent expert witnesses retained and compensated by the court, that there'd be a process for ensuring consistent decisions from case to case in one way or another, and finally, that to promote consistency in non-economic damage awards and also horizontal equity, similarly situated claimants treated similarly through the system, we would have schedules whereby, based on patient circumstances and severity of injury, similarly situated claimants would receive similar amounts. Now, this could be an administrative system. It might be in the judicial branch, but ideally we would envision this as an administrative approach. But fundamentally, it would be designed to expedite compensation to patients who've been injured, to use the best available evidence we have about what works and what doesn't work in medicine to determine liability and compensation. And finally, it would have strong linkages to patient safety initiatives and structures to create that feedback loop so providers could learn from their mistakes and hopefully prevent them from happening in the future. There definitely are a range of similar systems around the country and around the world. There are a number of specialized court processes within the judicial branch for business transactions, for business matters, for science and technology cases, even more closely aligned. There are administrative systems both in the U.S. and overseas for compensating the medical injuries. In particular, in Florida and Virginia, there are some limited programs for compensating a certain subset of birth injury cases. And then the Scandinavian countries and also New Zealand have really well-functioning, well-designed administrative compensation systems that have a long history of expediting compensation to injured patients, helping to promote safety, improving efficiencies, reducing adversarialism. And these are the key benefits that we see in an administrative approach to medical liability compensation. We've seen quite a bit of interest and support from this proposal from a range of different quarters, both sides of the aisle. The Republican Policy Committee in the U.S. Senate, the Democratic Leadership Council, the Manhattan Institute, the Progressive Policy Institute, which are right and left-leaning organizations, respectively. We've seen support from consumer organizations like AARP, the Joint Commission, and other quality organizations, lots of provider organizations. The Institute of Medicine has called for demonstration projects, which generally track these ideas. We've seen quite a bit of media coverage and support from publications including the Times, New York Times, and the USA Today, and others. So perhaps most significantly, in a poll we did perhaps 2.5 years ago, nearly 2 in 3 respondents liked the idea of having a special process for resolving medical injury cases. So we think this is something that has not only stakeholder support, but the potential for broad public support as well. Given that, it's not surprising that we have seen proposals in the legislatures, both at the national and at the state level, to create health courts or pilot projects in one way or another. There were bills in the 109th Congress that would have facilitated the creation of pilot projects, both in the House and the Senate. And there are bills in the works in both Congress, or both houses of Congress right now, which we're expecting to see introduced within the next month or so, that would propose the creation of pilot projects. We've seen state legislative initiatives advanced in probably 6 states, and there's a lot of interest around the country in this concept as well from other states. And when we think about this sort of question of how do you translate research into policy, well, clearly there are a number of ways which you could slice it and dice it or grind it up. But when we sort of hash it out, there are 6 ways in which we've seen the proposal to date translated into specific policy initiatives at the state level. We have seen, first, proposals in a couple of states, Massachusetts and Pennsylvania, to create administrative compensation systems at the provider level, that is at a hospital or integrated delivery system, on an opt-in basis for patients, where they incorporate all the other elements of the proposal. We've seen proposals in a couple of states, New Jersey, Illinois. There's a bill about to go in New York that proposes the creation of a carve-out within the existing judicial system for handling medical liability claims. In Maryland, there's been a proposal to have a special docket or case management system for medical injury litigation. In Tennessee, there's been an interesting initiative that's launched around the retention of neutral expert witnesses in medical malpractice litigation. In Maryland and Ohio, there's been some work done around judicial education, particularly addressing medical malpractice, medical liability issues. And then finally, in a half a dozen states or so, we've seen substantial interest in and culminating in a legislative commission or task force to look at the feasibility of establishing a health corridor administrative compensation system in the state. So lots of ways that we've seen interest in this proposal. We'll expect to continue to see that as the year goes by. The particular genius of American domestic policy is that we have 50 or 51 laboratories for policy experimentation, and we expect to continue to see 1,000 or 100 or at least a couple of dozen flowers blooming around this issue around the country. So I hope I haven't been too much on 78 RPM on this. Have I? Okay, good. 78 is generally pretty good at 5 o'clock in the afternoon. But I want to thank you again so much for your time, for the honor of being here this afternoon. I'll be happy to take any questions at the appropriate time, and certainly we hope to have a chance to connect with you, to hear your impact or input, and to work with you within your schools, institutions, and home states. So thanks very much.
Well, now we'll see if Paul Rubin can live up to the admirable punctuality of the first two.
I only have one slide, so that will help. So we talked before, people were talking about stare decisis, and Wally Olson talked about getting a mule back in, I guess he's gone, but getting a mule back in a barn. So I'm a fairly radical guy, and my proposal is you shoot the mule and then you can push him in whichever way you want. And when I talk about tort reform by contract, I'm sort of talking about shooting the mule. So I want to start off with this slide and end with it. It's sort of, I'm concerned with products liability and malpractice, but there's two sort of theories of the tort law that are floating around. There's the classic theory, and I'm an economist, so when I talk about classic theory, I guess I mean Landis and Posner or Chevelle, but probably the classic legal theory as well. The purpose of tort law is to reduce risk. In this theory, most damages are what economists call pecuniary or compensatory, not pain and suffering, but most damages are for economic losses. And the key thing about damages for economic losses is people want insurance for economic losses. People buy insurance for medical care. People buy first-party insurance for lost wages. So people want to insure against economic losses. On the other hand, as we'll see, people don't generally want to insure against non-pecuniary pain and suffering losses. We never see people buy that insurance when they're given a choice, and their economists can explain that in terms of the shape of the utility function. But the basic point is, when you give people a choice, they buy insurance against compensatory lost wages. They don't buy insurance against pain and suffering. So that's one point. A second point is, in the classic theory, we sort of ignore transactions costs. We know they're there, but we don't pay much attention to them, so we just assume that there's compensation. The last 2 points are key. Accidents are between strangers. In an auto accident, for example, people have no ex-ante relationship. They're strangers. They're legally unrelated to each other. They can't contract with each other. Tort law governs those interactions. And finally, the activities that classic tort law deals with are risk-increasing activities. So driving a car does lots of things, but it increases your risk of being in an accident. So we want people to consider that risk. We want them to internalize that risk when they make a decision as to how much to drive. And tort law also has the function of, sometimes has the function of inducing people to internalize that risk. So given these assumptions, Tort law has the effect of reducing overall risk in society. It's a good deal for people. It deters harmful behavior and leads to efficient outcomes. If we look at the modern tort law, and products liability and malpractice, which we've talked about today, the claim is that there's actually some risk increasing functions of this tort law. And let's go and look at each of the things I talked about. I said on classic tort law, damages are pecuniary, but in today's world, about half of damages are non-pecuniary. Pain and suffering is about half of the damages that are awarded. But remember, these are damages that people don't want to pay for. They don't insure against them when they're given a choice, and nonetheless, they come with the tort system. So about half of damages are non-pecuniary. Second point is, in the classic view, we sort of ignore transactions costs, but we know that in the real world, transactions costs themselves, as I tell my law students, transactions costs are the fees of many of the people in this room, but those transactions costs, legal fees, are another half of the system. So for every dollar that goes through the tort system, only 25 cents, actually about 22 cents, goes to compensate people for economic losses. In other words, only about 1/4 of the tort system goes to pay for insurance that people want to buy. The next point is the parties are not strangers. Doctors and patients are not strangers. Manufacturers and consumers are not strangers. They have a prior legal relationship. What does that mean? That means that whatever damages people collect when they're injured, they're paying for up front in medical fees or medical insurance premium or prices of products. The damages, the doctor writes the check, but ultimately that money has to come from somewhere. It comes from patients or from patients' insurers who get their money from patients. The money comes from the people that collect. And finally, the activities that modern tort law covers are risk reducing rather than risk increasing in many cases. Doctors are risk reducing overall. When they make a mistake, they increase risk, but overall, doctors decrease risk. If you look at the, last time I did this about 205, but if you look at what used to be the American Trial Lawyers Association website, they list their litigation groups, and about 40% of those litigation groups were aimed at doctors or drugs or other risk-reducing products. So what does all of that mean? It means that, one effect, people buy less risk-reducing activities because bundled with the price of the risk-reducing activity is this insurance that they don't want. Since they don't want the insurance, they don't want to pay for it. They may buy less medical care. That could lead to increased risk. And in a paper that I was not asked to present, but a paper with Joanna Shepard, looking at the effect of tort reform, we find that tort reforms, in many cases, overall, tort reforms lead to fewer deaths, fewer accidental deaths, through essentially this mechanism. It's probably through the mechanism of fewer doctors available in emergency rooms, and as a result, more people die. When there's no tort reform, fewer people die when there is tort reform. So we have the right-hand side variables leading to increased risk from tort law, the left-hand side variables leading to reduced risk. What does that mean? Well, to me as an economist, it means that there's a trade-off there. Tort law goes both ways. It can either increase risk or reduce risk. How do we make a decision? Well, I like free choice, so I say we should make a decision by allowing contract. And you know, as I think Marshall said this morning, it used to be that many activities that are now covered by tort law were covered more or less by contract. I would like to go back to that world. That's why I say shoot the mule, allow people to contract with their doctors, to sign waivers, binding waivers that would say, if you're injured, if I agree not to sue, probably for things like non-pecuniary damages. If I'm injured, I agree to sue only for lost wages or whatever. And the advantage of contract, of course, is I don't need to stand here and decide what the contracts will look like. The marketplace, people will sign their own contracts. We heard John Vail say a little while ago that most tort reform puts power in the hands of elites and takes it away from consumers. I think modern tort law takes powers away from consumers because no matter how much I want to, or any other consumer wants to, he cannot say, I'll take a lower payment or I'll sue for a lower payment and pay you a lower price. The courts have written that contract. The contract of adhesion is the contract that the courts have written. They've said, we will not allow you to waive these rights. We will not allow you to waive this right to sue, no matter how much you want to pay. So I think if we think about replacing tort by contract, if we think about it in terms of empowering consumers, I think we'll have a better political case. So we're not taking away the right of people to sue. What I'm advocating is giving people rights to sign contracts. And if we think that medical courts are the way to go, well, give them that option. And of course, the proposal we heard a few minutes ago does say people can opt in or opt out. That would be an example. You say, here's another system of courts. If you want to contract for these courts for your medical thing, that's something you can do. I don't know what the solution would look like. As I say, that's the beauty of contract. People can make their own decisions as to what it looks like. But as the world exists now, they can't. We force them to accept a contract that's written by the courts. I would like to give them back the option to write their own contracts.
So for this session, we have no commentators who will give us the rest of you a lot of opportunity to charge in and accusations, attacks, whatever you wish. Yes.
Actually, this one is, Michelle, on your proposal. I wondered if you could talk a bit about why not compensatory damages in terms of a schedule. And you talked about non-economic damages, and my thoughts immediately jumped to it would be possible to have one for compensatory damages. Just a point of curiosity.
It's not for any technical reason. I think where most of the policy concern about equity lies is in the non-economics, where there just is very little guidance for juries in being able to award them, whereas you at least have economic expert testimony to guide you on the compensatories. It's also touchy politically, so given that it doesn't seem to be a big problem, yet it is a big political barrier, we decided not to go there.
This is for Michelle or Paul, a pretty neutral, easy question. How, you talk about a provider opt-in. I think it's true that most claims involve multiple providers. How would you deal with that? Would you be trying one case in the judicial system and one case in the health court? Would you bifurcate?
The way that's likely to work is that you find it work better in an enterprise liability situation, and at least in Pennsylvania, the proposal that's come down the pike would require the hospitals and the physicians that were participating to agree to a joint defense.
So part of the proposal would involve, could involve an enterprise liability component.
Right, and go ahead.
Yeah, not necessarily enterprise liability in the sense of shifting greater liability from doctors to enterprises, although that's an idea I would also support, but rather that we would look for the demonstration projects to be run initially in systems that integrate their insurance arrangements between physicians and hospitals, like academic medical centers, so you don't run into these problems. I think once we got a better sense of whether the idea is going to work, then we take on the bigger problem. What do you do when you have a community doctor in a hospital with a separate insurer, which is more complicated?
We got Ronan up here with
Question for Michelle. Why this, I forget the name of it, avoidability or preventability? Why not all the way, either way, no fault or strict liability?
Well, I think from a technical perspective, there's no question that no fault is preferable. It's much cleaner, it's easier, it's faster, it's just a heck of a lot more costly. And I just don't think there's a political tolerance right now for compensating all bad outcomes, regardless of whether they were preventable or not. And if what we're talking about also is encouraging socially efficient levels of precaution taking, it's not clear that a strict liability rule gets us there either.
Why not?
Because we can't, doctors can neither foresee nor prevent non-preventable events.
That's right. Yeah. Can I follow up?
a brief follow-up.
Well, usually the theory about strict liability versus negligence is that both provide incentives to take care. So that I think may be less of a problem. But going back to your previous point, do you know that the litigation costs associated with avoidability are higher than the compensation costs associated with no fault. That's not, I can't remember if you kind of, is that part of your simulation study, or am I confusing here or something else?
So, yeah, we actually can sort of bootstrap that from some of the earlier epidemiologic studies of medical injuries that were done. And those seem to tell us that of all injuries, about half are preventable and about a quarter are negligent, roughly.
I don't think this mic is on, so I'll just have to.
It is.
It is? Okay. I was, if Paul is right, and I'm not saying he is, then it would, I wonder whether the system that Michelle is advocating would, if we already have over-enforcement, would lead to even more over-enforcement. I understand that you, of course, argue and you hope that you would get a better set of enforcement incentives. But talking about what's preventable, I think, still brings in the problem of the current system with a terrible problem with hindsight bias in looking at what's preventable. You know, and you talked about, you know, records on errors and stuff. So you know, whatever, 20 years ago, there's the Harvard study based on looking at hospital records and find a 10% error rate. Well, then we have a much better study done by serious errors. We have a much better study done by the American Bar Foundation, and they found error rates about 50%. 50% of the cases of inpatients in hospital service had life-threatening errors made. And if you start saying, is that preventable? Well, okay, maybe half of those are, but you're still going to have a huge amount of errors that people are going to think are preventable but aren't preventable. And so I wonder whether the system would still be extraordinarily difficult to sort out. I understand why it might be better, but if we already have over-enforcement and we have a lot of hindsight bias, I'm not sure that you wouldn't be worsening the kinds of things that Paul is talking about.
I mean, I think that I think Michelle will answer or has something to say. But I mean, the thing that I would say is that we're really pushing for pilot projects, not a wholesale change in the system. So this is the beginning of a process to begin to investigate alternative methods that might lead to better outcomes at the end of the day, that could create a predictable framework within which healthcare providers could provide services that would be more consistent and predictable for patients as well. So we certainly don't have all those questions answered, but again, pilot projects, limited test runs or demonstrations are really what we're after.
I think you're right that you can never eliminate the problem of hindsight bias unless you just stop making any judgments about preventability altogether and just create a pure social insurance scheme where if you get hurt in the hospital, you get money. That's it. We're not going to look at preventability. But I think one thing I like about the health court idea is that for a range of events, there is an attempt to determine prospectively, based on clinical evidence, what do we know about events of this kind, rather than on a case-by-case retrospective determination, just did this plaintiff have an avoidable injury? And there are actually a lot of events that the patient safety researchers have taken on and said, look, 60, 70, 80% of the time, based on what we know about medical causation and how hospitals are run, these are avoidable events. Now, there's still some degree of hindsight bias. That's true in any avenue of safety research, whether you're talking aviation or nuclear engineering. And I wouldn't cast aside efforts to figure out what kind of medical harms we can prevent simply because there's that problem. But I do think that this system, because it has some prospective element of determining avoidability, gets at it a little bit better than the tort system does.
It seems to me that when a patient and a doctor enter into a relationship, this is a very special relationship. The patient often is putting their life in the hands of the doctor. They're trusting the doctor to do all sorts of things, and frankly, at that level of trust, you never really think much about a bad outcome. And so, given that we're talking about waiver of certain rights, like the right to trial by jury, things like that, and to waive such a right, it has to be knowing and intelligent and voluntary. That's one reason why when courts look at the criminal area, they say that it can't be a waiver in advance. You can't have the police walk down the street, we're going to get better police protection in this neighborhood if you sign this waiver so that you give up your right to see an attorney if we happen to arrest you, and all these sorts of things like that. It has to be after the dispute has arisen. And what both proposals basically do is ask you to sign and opt into something before you know that there's going to be a dispute or the nature of the dispute. It strikes me that this is problematic from a number of different perspectives, but in addition to that, you've got the further problem of trying to figure out what is the quid pro quo you get in return. Possibly lower premiums on your personal health insurance, but that doesn't affect the medical malpractice insurance, and there's a lack of sort of privity in your model, Paul, there. But at the same time, it seems to me that you're not sure you're getting anything. You're still going to have to prove causation, and that's the bulk of what a plaintiff's lawyer has to do. Once you prove causation, proving the economic damages is relatively easy, and that sort of thing. So I'm not sure there's any quid pro quo, and of course quid pro quo is what allows you to go into the administrative system for workers' comp or something like that, and so it seems to me that it's built on sort of a false premise here.
There is a quid pro quo, especially in the core model where we'd be expanding the standard from negligence to avoidability, so it would bring into the zone of compensation.
I'm still saying, I don't think there's any advantage to dropping it to avoidability if you still have to prove causation, which is what you said, Michelle.
Yeah, I respectfully disagree. I mean, I think causation is a big part of the picture, but proving negligence is not trivial. And it's not simply that one proves causation and then goes immediately to a determination of economic damages. That it's a big deal to try to make out a deviation from standard of care, particularly for a lot of these injuries where they are in the gray area, where, you know, shouldn't have happened, but often does. How do we deal with that kind of injury? And that's exactly the kind of injury that I want to be able to offer people money for.
But given that, and you know, it strikes me, you know, many plaintiffs' witnesses, doctors who are witnesses, are now being reviewed by their medical societies for the types of testimony they give. This is often testimony that you know, hardly amounts to malpractice in the nature of the testimony, but yet they're facing these kinds of sanctions, which is chilling the willingness of people to go forward as witnesses. And I can't imagine how, you know, making this question about avoidability something that it turns on would somehow insulate these independent experts wherever they might come from, because I doubt if there's anything truly independent about any expert, that you know, whether they would not face those pressures from within the profession that also might cause them to lean in a direction.
Well, I mean, I think the simple answer we have to wait and see, but, you know, I'm pretty deeply embedded in patient safety research, and I do see there within hospitals, within the medical profession, a tremendous focus on preventing avoidable outcomes and acknowledging that those things happen. And I do think to a doctor, it is different to say, this shouldn't have happened in your hospital, than to say, you rendered substandard care. So, you know, I think using independent experts is going to get us part of the way, but I do think that there is a symbolic difference for the medical profession between an avoidability judgment and a negligent judgment. And there's a difference for claimants as well in terms of the burden of proof.
Let's decide of the room for a few minutes.
Thanks. I'm interested in two things, Michelle and Paul. Firstly, in whether you've considered more specifically the mechanisms that you propose to improve patient safety, what you just talked about in terms of the perspective, how would you integrate that into your administrative system? Because as we know, both God and the devil live in the details, and that could be an extremely important detail in terms of achieving your results.
Yep.
And secondly, whether you've considered pilot projects that do indeed have a no-fault system, which you said you've rejected, but a number of the no-fault systems, like New Zealand's, for example, are no-fault, but the people give up all pain and suffering damages. So have you considered that option, that it's no fault, and it could be a pilot project, but you get no non-economic damages? Now, the quid pro quo for many people for opting in for that would be improved access. I mean, part of the problem in California, for example, with MICRA is that if you're poor, you can't get a lawyer to represent you, even if you have been very badly treated and negligently treated by a doctor, because the cap deters lawyers from taking those claims. So for people below a certain income level, this would be a great incentive.
Well, I'll be happy to answer that. I think from the safety perspective, we would see a number of overarching ways. One is that you would take de-identified information from the adjudication process and push that back to provider level to facilitate root cause analyses of what went wrong.
And then you would also push that data out to the patient safety authorities to make it available for academics and other researchers to do epidemiological analysis of this sort of data to get a broad sense of the patterns of errors that are occurring. With the basic idea is to encourage, to reduce the stickiness of information flow about things that have gone wrong in the treatment, to build that data warehouse so there's more data there to look at and analyze.
One follow-up. Would you say that there was causation without any evidence or need for argument if a hospital then, in the next case, hadn't followed that particular guideline?
I mean,
So,
I think
for
it
example, something like doctors washing hands before they see patients. I mean, the evidence here is very, very clear that if you have a zero-tolerance hand-washing policy, the rate of hospital-induced infections goes down dramatically. So that if a hospital then refuses to enforce such a policy, once your health court has said all hospitals must do this, then causation would be proven if someone gets an infection in a hospital that they didn't enter with.
I'm not sure if causation would be proven, but avoidability, I think would. Yeah, you have a guideline being issued as a result of data that come out of the health court, so this kind of injury can be prevented through X, Y, and Z, and then they don't do it. Yeah.
And as far as the pilot projects that test different standards of care, that's absolutely the case. And we see really, in terms of the legislators, policymakers, and interest groups around the country that are interested in this, that there are a whole range of different things that would articulate the programs that might be created. And in particular, in Colorado, we're seeing some interest in the idea of trying to build a new program that is based on and learns from the ample lessons to be learned from the Virginia and Florida experiments with birth-related neurological injury compensation, to develop a new approach that really takes care of families and babies that have suffered injuries by bringing in private dollars but also leveraging public resources to improve efficiencies and really get the money to where it's needed. So, and that potentially could work on a broader than avoidability standard.
I have a question, but I don't really need this. But before I do have a couple of concerns, especially around the issue of patients giving up their rights in the courts to access the court system for redress. And I think it's pretty clear that this proposal would do that it's bad for patients, it's unconstitutional. Our organization has a very detailed report about this. I hope you will read it if you're interested. But my question is this: the decision-making authority of the health court scheme is put, my understanding, in the hands of the hospital or insurer or some so-called expert. And that this person has perhaps some training in health, but that's to me very vague, so I'd like you to expound on that. Secondly, the schedule that's developed would assign a certain amount for a lost eye, let's say, or a limb, without looking at the circumstances of that injury. So that if somebody was injured on the job or injured in so compared to another, there's no individualization of the causation of the injury. And so I'd like you to comment on that. And finally, I'm kind of appalled, I don't know if anyone else heard it, but to say that doctors don't know what negligence is, Michelle, is pretty shocking to me. Because in this country, we know what negligence is. We have reports of medical errors. We know that the vast majority of medical errors, I'll just finish this and then they can please respond, but the vast majority, over 75% of medical errors, are caused by, I think, 5% of the doctors in this country. And no one has talked about this today, and no one has said how that's going to address the issue of patient safety.
Well, let me take some of them and I'll let Paul do some. First, thanks for your comments and for coming. Let me just talk about the last two things. The question about whether doctors know what negligence is. There are clearly some instances of medical care that we can all agree are negligence and that the law recognizes the negligence in all cases. But one thing we found interesting in the studies that we did, most recently this large study of 1,500 claims that you cite in your report, is that even we had these doctors reviewing this complete medical record, the complete litigation record, after the litigation was over. So they had everything. They had the depositions, they had the expert witness statements, all of the information that came out of the litigation. And still in a very substantial portion of those cases, the doctors came back and said, I'm not sure. Close call, 50-50, maybe yes, maybe no. So I'm skeptical, particularly at the outset of litigation, when a lot of decisions are being made early in the litigation, that people really know what happened or whether the care was substandard. And that's one reason that I object, as you do, to people characterizing a lot of lawsuits as frivolous, because I think it's not clear oftentimes until very deep into litigation. But I still think to a lot of doctors in their everyday care and in the process of litigation, it's not clear to them that what happened was negligent. And I just don't believe in that standard as a deterrent or as something that's really helpful to guide doctors. But I wanted to respond to also this figure that you raised about the 5%, the 75%, because this gets thrown around a lot, and I don't like the way in which it's used. That data point is that 5% of the physicians in any given year are responsible for about 50% of the malpractice claims costs. Not that they're responsible for a certain amount of the errors, but more importantly, what gets missed is that from year to year, it's not the same 5%. Okay, what it tells us is that a small number of claims cost a lot, but it's not that we can point to 5% of the doctors and say, you're bad. So I don't find that piece of data helpful in telling me how to reform the liability system.
Well, there is data that many doctors that have repeat malpractice, constant malpractice suits, that states are not working with to weed out those doctors. I mean, there are problems with doctors going from state to state who have malpractice awards in one state and move to others.
You're absolutely right, but that's not going to solve our problem. It's not going to solve.
That's not going to solve part of the problem.
Oh, it'll solve part, but not enough to get us where we need to be.
I would just like to add a few things. From a constitutionality perspective, I think a room full of judges and law professors would know more than anything that at a certain level, the question of is it constitutional or not would depend upon who you ask. You come up with a legal rationale for lack of constitutionality or constitutionality. We've come up with what we believe are very strong arguments in a number of states as to why state legislators could create a mandatory administrative compensation system for compensating avoidable medical injuries, particularly as part of a broader package of health reforms that I think would be very effective. Would it be tested? It certainly would be tested, but I think that there are very strong arguments that can be marshaled. I mean, would a legislature do that? Could they? They definitely could. Would they? I don't know. I mean, that's the process that we're working through. Just would add that the high risk, the 5%, 75% number, it also, you need to take into account the fact that certain physicians practice in higher risk specialties where there's a higher likelihood of error. And then finally, on the schedule point, I know I need to communicate more clearly, but I'm not sure how much more clearly I can communicate the fact that what we envision with the schedule of non-economic damages is something that would ultimately be based on patient circumstances and severity of injury. So we wouldn't see this as a flat number for the loss of your eyelid or of your finger, but rather as a consistent metric that would lead similarly situated claimants to similar amounts. And is it perfect? Nothing's perfect. There's no perfect system. Is it perfect that jurors pull a number out of a hat with no idea of what they're thinking about? That's not a perfect system either. But we think that a schedule could improve consistency, predictability, and ultimately fundamental fairness in the system.
But the underlying assumption, I just want to say, the underlying premise that you're operating under is that jurors are not able, that they're runaway juries, that they are not able to discern and understand the complexity of the case, and therefore they are awarding disproportionate amounts based on an injury. There's an underpinning here that jurors are not able to understand that.
I flatly disagree. That's not our point. I think we could do it much better. There are alternative ways, but I personally have a great deal of respect for the jury system.
We have another question back here.
Yeah, just an observation and two quick questions, both from Michelle, and she's heard them before. The observation is that we have the tort system operating maybe in parallel, probably not in series, with our state licensing arrangements, and state licensing has been a problem for a long time. And I don't think you're suggesting, or should you, that this will pick up the slack from that problem. We actually do some things to strengthen that. But this is not a new problem. State licensing has been an issue forever. It used to be the only things that would get you to lose your license were the 3 A's: alcoholism, adultery, and worst of all, advertising. So we've come some ways from there, but we still have problems. Now the questions, Michelle. First, choice of entity. choice of entity. I mean, you're using healthcare providers as the sort of decision point. And as you know, there's been this debate in the area as to whether it makes more sense to use payors as opposed to providers. And so I just wonder if you could talk a little bit about your decision to hold fast to providers. And then secondly, the voluntary adoption point. I'm a big fan of experimentation, but as work you've done has pointed out, there's significant underclaiming in this area. And to the extent that health courts end up increasing the number of people in the system and or increasing the awards per person, depending on voluntary adoption, when it's going to cost the participants more as a result of adopting, it's hard to see the direct economic incentive for them to do that.
Yeah. So on the entity question, as you know, we've toyed over the years with locating this in managed care organizations, and I think it basically comes down to how can we create a closed system to experiment with this. What you don't want to have is a single provider dealing with a mixed group of incentives, some of which emanate from his tort patients and some of which emanate from his health court patients. Much cleaner to just capture a whole entity and all of the doctors within its walls and see how it works there, I think. But having said that, we would link it to plans in a certain respect in that they would be one of the points of entry for patients into the system. That would be one opportunity that you'd have to consent and opt in, is when you sign up with a plan that works with a covered provider. On the voluntary adoption question, you know, you're raising a real good point that the insurers have come to us with a lot of times, which is what's it going to cost for an insurer to participate in that. And we're working on some modeling now to try and answer that question. But our best guess is, because if you appropriately control damages awards, hopefully it'll come out to be essentially cost neutral. One thing we're hoping that some states would put in place would be some assurance on the downside risk in the form of subsidized reinsurance or some other kind of protection.
My name is Richard Clark. I'm a physician. I actually take care of patients routinely. I do it all the time. I take call. If you are showing up on Sunday at our hospital, I'll be anesthetizing you. I've listened with some interest to the discussions here. I must say that the feeling that I get at the end of the day is that if they're as bad as the malpractice system is, I can see how we could make it worse. It strikes me that it is a very interesting proposition to replace one non-functioning bureaucratic system with another non-functioning bureaucratic system. And the idea of replacing one set of people who spend a lot of time hashing out the differences between words and the meanings of different kinds of conditions with a different set of elites is extraordinarily provocative. It is indeed very frightening to those of us who actually have to deliver care. Ladies and gentlemen, you are facing a major crisis, and the crisis is not the tort system. The crisis is the healthcare system. And the tort system is a rather minor detail on the edge of it. $2 trillion a year is what we're spending on the healthcare system. Torts is just a minor little detail on the edge. It may not work very well, but I guarantee you that the kinds of forces that are out there are driving towards an even greater separation of those who have from those who have not. And right now, the only system that I see out there that offers any prospects for protecting the individual rights of small people is the tort system. Do you understand what you are talking about when you're talking about giving this up? Why would you choose to create a new set of elites, a supposedly, quote, neutral, who knows what neutral means, unquote, group of people to adjudicate causality? I have 20 years of research in patient safety, and I will tell you that none of this sounds attractive to me. It sounds like a recipe for disaster. And indeed, I would suggest that if you do not do something to reform the tort system as it currently functions, the alternative is going to be even worse. What I would recommend to you is that rather than trying to reform the tort system in the sense of trying to make it produce some limits or putting some caps on it, that you think about trying to inform it with some science. And I think the failure to inform with science is the real problem here. You guys don't know how accidents happen. You don't get real data. You don't really know what's going on. Most of the stories you hear about how medical accidents happen are wrong. Most of the RCAs and the hospital reports and the confabulations of various kinds of experts are simply wrong. You guys barking up the wrong tree.
I don't think I need a mic. I hail from my colleague down the road from the University of Chicago. I'm a pathologist. I'm in one of those areas where I see the errors, and I have to agree with him. The errors are enormous, and the cover-ups are enormous, and the data is incomplete. As the one woman mentioned, to lose an eye, if you're an individual, that's great, but the context of that person may be limited to vision that is reduced in the other eye, it brings out a distinction with a great difference that you mentioned. If you're bilateral vision and you lose one eye, you certainly have the benefit of the other. When you look at the issues that have been brought out about gathering consensus and having this board that is going to somehow help, I am here to tell you, because I was given an assignment to look at screening. And screening varies whether you're on the East Coast and West Coast, whether you're in a rural section and whether you're in a city. But the main thing, I believe, that helps explain that 5% is where you are in terms of your years of medical practice. If you're someone who has been out for a long period of time, you do a better mix of assessing what to do with your patients than if you're someone who's just out of residency and approaching it. And there's good literature on that, I'm sure you know, years of experience. But now we're beginning to see some forces that are driving rapid judgment. And we have software that actually does better than some clinicians, simply because it's been driven through models that, as Michelle mentioned, are more analogous to engineering and to other areas like nuclear safety. So the forces and the drivers are not aligned. And that's what I think Dr. Kleck was saying. When you look at payers, providers, insurers, and the patient, we don't have a system where value is continual throughout the chain. And so until we have a less fragmented system, we're not going to get a straight story. Because you can't even get consensus among medical professionals on how to adapt new technologies. That's the space that I work in. And people, if they're longer out in practice, don't want to move to newer diagnostic tests because they don't understand them. So I don't know what the answers are, but I can certainly tell you I support what his research has demonstrated over and over. Safety in medicine comes right out of 20 years of his work, and I see it as a pathologist. It's simply that bad. It is simply that bad. And I don't know the answers, and I understand what you're struggling with, but screening gets tucked away, they don't do it, and we really do discriminate based upon economics, our healthcare. That's how we triage our system.
Well, I think, fundamentally, we've certainly never claimed to have all the answers, and frankly, we're happy to have input from people like that. I mean, I think the point that Dr. Kleck was making is that there's a fundamental issue with the way that science is applied in the system, and our hope is that a model like this in one iteration or another might help with that. But we certainly value those input.
I think the idea of trying to create another quasi-judicial system to handle these sorts of things, which is what you're talking about, is itself a fool's errand. And I think that the efforts to do that will result in yet another bureaucracy with yet another set of rules and the same kind of elaborate stuff, but without the protections that the legal system actually has.
Well, if I could just, I have trouble sort of trying to organize the question out of some of what you said, but let me respond to one thing that that did resonate with me, which is this perception that the tort system is consumer friendly, which is just something that I flatly reject based on the data that I'm aware of.
The tort system is terrible. It's terrible. What you're proposing is worse. That's the problem. It's not that's not a step up. That's a step down.
Let me tell you why I don't think it could possibly be worse. So we're talking about a system in which 98% of the patients who are injured by negligence don't file claims. So
No, you're talking about 98% of the patients who are harmed, not injured by negligence, who are harmed. You've just equated all harm with negligence, which I do not agree with at all.
Can I finish? So this figure comes out of 2 large-scale studies of medical injury that my colleagues ran. Okay.
And-
I'll let you respond.
Yeah, I will.
Okay.
I
All right,
think maybe
so-
this could go on in the hall. We have some other questions.
Well, I'm not sure I want to follow that rather electrifying interaction with a rather boring and tedious point from a scholar that I'm about to make. I have 2 points, one a conceptual point and one not quite a conceptual point. There has been criticisms here of some of these alternatives to juries on the ground that any criticism of the jury system is equated with somehow thinking all jury decisions are wrong. You can recognize that juries, like any other decision-making process, can make mistakes and think that for the most part it works pretty well and thus look for a solution to resolve those mistakes. So simply to suggest that sometimes juries, and maybe even 15-20% of the time they're wrong, doesn't mean much about what you think about juries as a whole. And on that point, I mean, we know a lot about jurors, and what we know is that they're quite good, like anybody else walking around in society, and processing information they're familiar with and making intelligent decisions on that basis. And like everybody else in society, they're not very good at processing information they're not familiar with and making decisions on that basis. And what you're talking about in this context today, from my distant point of view, is data and information that they're not familiar with. So I mean, if, for example, you can't get resolutions to these problems from experts and people who study them, the idea of giving them to juries is like just giving them to a random process for exactly this reason. Now, having said that, my last point is it actually does make a lot of sense to think of the jury as a randomizing process over things like the value of pain. But it's a randomizing process with a no upward bound and an obvious lower bound. 0 is a lower bound. There's no upward bound. So what would a statistician looking at that say? Well, like I showed you earlier today, you've got a problem on the upward side, you probably have a problem on the lower side too, and what you should do is come up with a way to force things towards a median. That's a perfectly plausible definition of what the fact of the matter is for pain and suffering, maps onto the proposals you're doing as well. And if you don't like that, you ought to come up with some other fact that those of us who deal with jury trials can be assured can be established in some kind of reliable way so that the rule of law really isn't disposed of in these cases.
I'd just like to say that I'm glad to hear you say that, and that is certainly something that we've considered and are supportive of in terms of thinking about how you might create a health court pilot project that retains the jury trial or that retains the jury as the ultimate arbiter of fact, but also puts in some sort of guidance to guide juries in a more educated way in determinations of liability and compensation.
I think we'll take one more and then we'll go into informal session.
I wanted to get back to Paul Rubin for just a minute. Robert Peck was saying earlier that people should only be able to opt in ex post to these kinds of contractual arrangements of giving up certain rights. But the problem with that is that if that's the rule, then I can't opt not to pay the lower, I can't opt not to buy the insurance that I don't want, that Paul was talking about. If you want to think of this conceptually, think of auto insurance. You can imagine an auto insurance company offering 2 policies, one to people who are going to want to claim pain and suffering damages in the event that they have an injury, and a different price to people who don't want to pay that, obviously a lower price. In the status quo, there are no such policies of the latter kind. I can't buy that policy, even though that's my preference, and if those were offered, I would buy it. And that's sort of that problem that I was just describing is what you want to have apply to all rights.
Well,
and so let me just...
what the Constitution requires.
Well, it's not constitutionally required for auto insurance companies to have their policies cover pain and suffering. They could easily, constitutionally, they could easily offer contractual policies that didn't cover pain and suffering. They're just not offered right now. But let me get to the point that I wanted to question Paul about. I'm afraid the trend's actually the other way, Paul, in terms of whether we're moving from tort to contract. I think we're moving from contract to tort, and I'll give you an example. In the area of say, transportation contracts for businesses to trucking companies, there is an ongoing effort in state legislatures across the country to ban indemnity provisions from contracts. The idea is that you shouldn't be able to indemnify against your own negligence. Of course, we all do that when we buy first-party auto insurance, so it's not a strange concept indemnify against your own negligence. But there are state legislatures across the country now who are banning that, and I think that we're going to see that trend of other kinds of contract terms that are going to be banned. So it seems like we're moving away from, and I should say that the upshot of that is that you're basically imposing the tort rule of let the damages fall where they are, or kind of distribute them under a comparative negligence regime is the result, whereas under the contract it would fall on one party or the other based on whatever the negotiated contract term is. What can we do to prevent that trend from developing? Because that's what I deal with more than even what you were talking about.
I guess I don't know. If I knew, well, I first wrote a book proposing tort reform by contract 13 years ago, and we still haven't done it. So I guess I'm not the right person to ask as to how to do it. I do think we can try to rephrase the debate in terms of, instead of talking about, as people have been saying in here, giving up rights to sue. I think if we can try to rephrase the debate and say we want to protect people's rights to make their own decisions, at least that may give us some play with the people who care about rights. I've always been amazed that state legislators are quite willing to pass laws with damage caps, which we've talked about a lot today, but not willing to pass laws that say we'll allow people to choose their own level of damages. So we really have gone to a world of elites, and we're not willing to let people make their own choices. I think if we try to push the argument in those terms, we want people to make choices. We want them to be able to sign contracts. It's in their benefit to do so. That's the way we have to try to sell it, I guess. But I'm not so I'm more of a policy developer than a policy selling sort of guy. But that would be that's the only thing I can think of, is try to make that point. But I do want to thank you for asking me a question.
Thank you all for joining us. This is the first public program of the Searle Center, and there'll be many more coming down the pike. And you're on our mailing list now, so you'll be hearing from us. And I want to especially thank Derek and Julian for helping us out with the plan. And thank you all for joining us. Have a safe trip home. Take care.